Well, I guess we'll get started. Thank you everyone for joining us. I represent the Consumer Federation of California. I'm their Associate Director. Thank you so much for being here and taking time out of your day. We're a co-sponsor of today's event, but we're co-sponsors alongside the Center for Responsible Lending, the Institute for Local Self-Reliance, CAMEO Network, and Poverty in California, and Tech Equity, who actually has an event upcoming next week that they would like to highlight. So we're going to give them a couple of minutes to do that right now.
Thanks, Yarissa. Hey folks, I'm Megan Abel, Vice President of Advocacy with Tech Equity. I'm going to grab my flyers here. Maybe you guys have seen this circulating around the building. Tech Equity is hosting an event next week on new polling results on how California voters are thinking about the issue of AI. This is our second year running this polling, so we'll get to see how voter sentiment is moving year over year and really drill down into some of the critical topics that folks are thinking about, including concentration in the tech industry, so really related to what we're talking about today. So I'm going to put these flyers on the table. There's a QR code for you to register. It's on Zoom, 10 a.m. tomorrow. 10 a.m. tomorrow. So if you have not yet registered, encourage you to come. I think it's going to be really interesting, particularly for folks that might staff privacy or judiciary or those types of areas. So we hope you can join us.
Thank you, Megan. And just would like to take the time to thank our co-sponsors, our CFC staff, and also our panelists for being here today. This event wouldn't be possible without them. Okay, so let's get to it. Today, we're excited to host the final event in our series. Are you one of the 19? I'm sure that you've seen flyers. You got it bombarded by our emails telling you to come to our events. And then throughout this series, we have explored how the concentration of wealth and market power affects not only consumer choice, but basically every aspect of our daily lives, including the access to fair wages, affordable food, innovation, and most importantly, competition. And competition is very important for all of our small business owners. These issues, as I stated, are especially important for small business owners, particularly those with fewer than 100 employees. Small businesses, if you didn't know, they make up the heart of California's economy. They make up approximately 96% of all companies in the state, and they employ more than half of California's private sector. So for that reason, we wanted to take the time today to be able to feature a panel discussion where we're going to get to hear from a few small business owners, advocates, and the enforcement experts about why this legislation, AB 1776, is so important. And it's a bill that ensures fair competition in California's economy. So today's panel is going to be broken up in 3 different segments. First, we're going to hear from Christin Evans. She's an entrepreneur and the owner of the Booksmith, an independent bookstore in San Francisco, as well as the Alembic Bar. And after her, we'll hear from Chief Operating Officer Mark Herbert, who is from the CAMEO Network. In his role, Mark helps coordinate the organization's efforts to empower, he's here, hello Mark, to empower the local communities and support the entrepreneurs with the resources that they need to succeed. And last but certainly not least, we'll hear from Tom Papageorge. Tom heads the Consumer Protection Unit in his hometown of San Diego at the District Attorney's Office. Throughout his career, he has drafted more than 40 successful legislative proposals, including bills that established California's identity theft statute and strengthened the state's unfair competition law and the Cartwright Act. He has also been recognized as the Antitrust Lawyer of the Year back in 2004. So start thinking of your questions, because he is truly a a truly to-go expert in his field. There's going to be a Q&A section at the end of this, so make sure that you prepare your questions so that the panelists can answer them. And with that being said, please join me in welcoming our first panelist, Christin Evans.
Christin.
Thank you. Yeah, Christin, please take some time to introduce yourself and your experience.
Of course. Hello, everyone. My name is Christin Evans. I'm a small business owner. I own a bookstore and a bar in San Francisco's historic Haight-Ashbury neighborhood. Booksmith just celebrated its 50th anniversary on Saturday. I was going to say, I'm not that old. I've owned the store for 19 years. I took over from the founder, Gary Frank, about 19 years ago in 2007. And Booksmith is a general neighborhood interest bookstore. We sell primarily new books. When I took over the bookstore in 2007, ebooks was a fast-growing market. Amazon was growing like gangbusters. It represented about 30% of the market. It's a lot bigger than that now. And we basically decided to try to do something that Amazon couldn't do, which is create great in-person experiences. So we focused on creating an inviting, welcoming space, hosting author events, having those shelf talkers on the shelf so you can discover books that you don't know about. We have booksellers that are informed readers that can interact with you and help you discover your next read. And we thought it was important, especially being in the Haight-Ashbury, to offer hospitality along with our author event. So in 2018, we took over a craft cocktail bar called the Alembic, which has really delicious cocktails. If you're ever in San Francisco, come check us out. We also have elevated pub food, is the industry term. And we host author events now with food and beverage often. And so I'm here to talk a little bit about how things have changed in the 19 years that I've run a small business, how things have become challenging in new ways, particularly as our vendors that we use to supply our services and our products have consolidated.
Just so that we get to learn a little bit about that experience from you, Christin, can you tell us a little bit what has been your experience trying to operate a small business in the Haight-Ashbury district in San Francisco?
I would say that it's always been challenging. Every downturn, every upturn brings new and different challenges. What we saw between 2011 and 2019 was an economy on steroids that increased the real estate costs across the city. And even though there was a lot of economic growth in the city, we saw in our neighborhood commercial corridor in the Haight-Ashbury, our number of vacancies go up substantially. So we had 5 vacancies in 2016, and we had 21 at the start of the pandemic. That went up to 32 during the pandemic. That's out of 150 storefronts. And then now, fortunately, it's down to about 14. But part of what we're starting to see again is the headlines every week of small businesses, including long-term legacy businesses, closing as a result of double-digit and triple-digit increases, demands from their landlords for increased rents. There is no commercial rent control that allows small businesses to have a sustained growth of their rent that's sustainable for their business.
Yeah, okay. And as you stated, small businesses occupy most of the storefronts in America's strip centers, yet an individual merchant often negotiates a lease alone. Christin, what happens to that bargaining relationship as the ownership on the landlord side becomes larger or more concentrated? And who does an independent storefront have to negotiate with? Where have the choices, do you think, where have they gotten smaller, and where has it become like basically like a take it or leave it type of situation?
Yeah, so when I negotiated my first lease, it was with a mom and pop landlord. It was 4 to 5 pages. It was in simple language. It was a fairly straightforward contract. Now we're increasingly seeing that with the corporatization of landlords, that we can often be presented with leases that are 45 pages long, that have full of legalese, that can cost upwards of like $5,000 just to have a lawyer or a real estate expert review those lease terms to help us negotiate what would be a fair agreement. So again, it's not like we have any residential rent control protections, like we don't have any protections from the upside. The only protection we have is the lease itself. So everything from like who's going to take the burden, the cost of increased property taxes, who's going to be receiving the burden of the insurance, the maintenance and repairs of the building. All of that is the landlords are trying to offload onto us. And we've seen that as the landlords have shifted from mom and pop landlords to more corporatized landlords, we're seeing more and more of those costs being shifted to the businesses, including with surprise hidden fees that pop up on occasion. In San Francisco itself, a lot of our neighborhood commercial corridors were identified in the recent upzoning plan for the Mayor Lurie's family zoning plan. So essentially, we're in the center of the real estate speculation. So we are seeing real estate speculators take over the property and negotiate with us very, very hard, leaving a lot of times businesses without the option of signing a lease because they couldn't make it work. And as we see those developments go up, all of those multifamily buildings that are providing much needed housing, unfortunately, we're seeing at the base level a lot of commercial vacancies. So about a third of the buildings in the Market Street and the Ocean Avenue corridors that have come up in the last 10 years are vacant. They're not really interested in leasing to mom and pop shops. They're looking to bring in formula retailers. The only thing that's really prevented that is some formula retail restrictions that we have in San Francisco. But even that, we've seen corporate interests trying to loosen those as well.
Okay. Thank you for sharing that. Yeah. Why do you think that pooling resources, information, and legal expertise change your bargaining power as a small business?
Yeah, so one of our local supervisors, Connie Chan, just announced a plan to introduce something called the commercial tenants' right to unionize. What had happened during COVID is the Japantown merchants that are a part of a strip mall that is focused on Japanese cultural offerings, restaurants, and so on, banded together, pooled their resources, hired a single attorney to help negotiate with the one large corporate landlord that was largely, present out of state, right? And so it really allowed them to have some leverage because they were working together to increase their bargaining power. But obviously, it's a cost savings, and it also kind of gets us to the crux of like really fair and truly fair equal terms that we can have as small businesses.
Okay. What happens to a commercial corridor when a business still has customers and it's otherwise viable, but they can no longer afford, the rent terms that are required for you to actually stay there?
Yeah, so, as we've seen, our growth, we are experiencing growth, but the growth is not keeping up with our other expenses, right? So if we see skyrocketing rents, we are also seeing skyrocketing insurance, utilities cost, everything is growing faster than our revenues. We're getting squeezed. And so what that means is that we are having to really be really judicious about staff time, so we cut back staff hours. We've really benefited from having programs like Cal Savers, and ideally we would like to see a more a universal healthcare kind of option available, but certainly the healthcare is continues to be a persistent challenge. But these are all the juggling levers that we have to work with, and when we are getting squeezed by corporate landlords and they're taking a bigger share of the pie, then other things that we do have leverage over get cut or hurt. And ultimately that impacts the customer experience, right? Mm-hmm. Where we have to raise prices, we have to reduce our customer service level, and so on.
Okay. One of the biggest things that we try to be able to highlight with this bill and with this series is just the bargaining power. Mm-hmm. What are some key things that you think we're not seeing on your side as a small business owner that you tend to struggle with outside of the rent control, like you've been able to highlight?
Yeah, so I think increasing, we're seeing like less options and less choice. Like we've seen a lot of small businesses in our neighborhood commercial corridors be dropped by their insurance providers and scrambling to find insurance options. And often the brokers are offering them one option. There's not a choice of options, and these costs are going up as a result. There are a number of, in my restaurant, we also are seeing with our food vendors the price of food going up substantially. And so, all of these things translate into higher prices on the menu. Yeah.
Okay. Well, thank you. Do you have any other key takeaways that you would like to leave everyone with?
Well, I think that we're time and due for commercial rent control. I think that in order to ensure a thriving ecosystem of sustainable small businesses, we need to have a fair and even playing field, especially as we've seen the consolidation of real estate interests, the leverage that the large corporations that have these large corporate portfolios have over small business tenants as consumers of purchasing real estate to provide you with services and products is really a challenge. And I think it makes sense when the initial prohibitions on commercial rent control were put in place, there really were more mom and pop relationships, mom and pop landlords and mom and pop small businesses. That's just not the case anymore.
Yeah. Thank you so much,
Thank you.
Christin. Okay, we will now pivot to Mark. Hello,
You want to
Mark.
take my seat?
We're all the cool guys.
No. I'm fine.
Okay. Mark, do you want to take a moment to not just introduce yourself, but also CAMEO Network, and just share what kind of work you do?
Sure. Before we do that, though, Kristin's correct that the recommendations that her bookstore gives are fantastic. When I went to visit Eric Larson, I still think about that book. It's a great book. So she's not kidding. That's a service that they have that no one else can match. My name is Mark Herbert. I'm Chief Operating Officer for CAMEO Network. So we are a national organization specifically designed to work with local communities to help them grow entrepreneurs. Like, we fundamentally believe that there's talent in every community to build entrepreneurs and to grow entrepreneurship, but oftentimes that talent is disconnected from expertise or resources or capital. And as you all know, and why we're here today is many of these entrepreneurs, our financial systems are not built for them. And so we work with over 400 business coaches, mission-driven lenders, like nonprofit lenders that work with entrepreneurs to help them start and grow their businesses. And then we work with those organizations, both on professional development training, so we do professional development. This is how you do micro lending. This is how you do technical assistance. And then we also do a bunch of community building. But then for today, we want to make sure that the stories of the clients, of our members, are part of the conversations that happen like in this building in DC. I was just on a call earlier today while I was late about the CDAA fund and the massive challenge that we're having with that. There's a bunch of money that's stuck in DC that should be in local communities. And so we're working to try to figure out, can we get those dollars to the organizations that actually work with entrepreneurs.
Thank you, Mark. So yes, exactly like you said, small and micro business owners are spread across industries and communities, and the challenges that they experience can be very difficult. And often it's the business advisors, the lenders, and the technical assistance providers that are actually working at the community level who tend to hear about those challenges first. CAMEO and its members has built a statewide network of trusted organizations with exactly those kind of relationships. How does your network see into the experiences of small businesses, and how can those insights contribute to a policy conversation like AB 1776?
Yeah, no, I appreciate that. I think it came up even at the press conference earlier. Angie from Bobo Designs,
Angie Chua,
she mentioned that she's having this issue with a platform, and then she realized she wasn't the only one. I think that's sort of the key to this, is that what we're excited about with this legislation and the opportunity here is we can build use cases of how we can really communicate to entrepreneurs and small business owners how they are actually unfairly bullied into really challenging business relationships in a way that maybe they don't realize is a problem, because that's just how it works for them. They don't know anyone else who's going through the same issue. And the opportunity is to provide tools and resources and support for those entrepreneurs so that they can have a level playing field. All the businesses that our members work with, they just want a shot. They just want to make sure that they have a shot to compete and to compete with the best organizations and the best businesses. And oftentimes when corporate power is leveraged specifically to target really small businesses to drive them out of the market or to disadvantage them, some businesses don't know that they don't quite sure how to respond. They think they're all alone. And so this gives us an opportunity to really identify ways to make it clear that those sorts of practices are not competitive. Those sorts of practices are not what the American dream is about. And so if you purport to say you support businesses and you support entrepreneurship and you support the merit and opportunity, then you need to make sure that you're supporting a level playing field. And this bill gives us the opportunity to get a little closer to that for entrepreneurs.
Thank you. What should policymakers understand about the needs and experiences of these entrepreneurs in particular as they consider AB 1776 and those other efforts to address the market concentration, and not just the representatives but also the staffers here today?
Yeah, I would say, and I think you've heard the numbers, but small businesses make up the vast majority of businesses. But a small business owner doesn't have time to come to Sacramento and walk the halls because they're trying to keep their lights on and they're trying to make payroll. And so oftentimes the folks that you're going to hear from in the building either have resources to hire someone to come do that for them, or their business is big enough where they are able then to actually resource someone to go and do that for them. So a lot of the entrepreneurs that we work with, they're just trying to make it work. And so a lot of what we learn is from the providers that work directly with them. And our goal and our hope is to make sure that we're arming all of the different technical assistance providers, all the different mission lenders with the information that they need so that they can help support those entrepreneurs as they're trying to navigate a really challenging marketplace, a really challenging dynamic. And so think about when you're talking to folks who say, hey, I represent business, I think it's important to ask about what's the average size and what does that mean and what industry are you in? Because I think business can be a big catch-all bucket. But what we find when we talk to really small entrepreneurs, mom and pops, Main Street entrepreneurs, right? They care about their employees. They don't think about their employees so much as a liability on their balance sheet, as so much as that's part of how my business is successful. And so there's a very different mind frame in small businesses that I think gets lost in some of the policy conversations. So I think it's important to really think about the size of the business owners and the communities that they're invested in, like Christin said, and not just is this business owner have a huge have a bunch of employees making a lot of money, doesn't necessarily mean that business has the best interests of all entrepreneurs and all businesses in the community.
Yeah, thank you, Mark. Okay, where do you see this bill fitting into the broader set of policies and the support that is actually needed to help the small and micro businesses compete? I know you touched on that a bit. Do you think that you can hone in on more specifics of how this fits?
Honestly, I think that's what I'm hopeful for. When this bill passes, I think there are business practices that are unfair, that happen regularly, that we just don't know about. And I think part of the challenge in having this conversation also with a lot of entrepreneurs is connecting the fact that that problem that you're having with the vendor is because of consolidation further up the supply chain, right? And it's difficult for them to connect that because they're just trying to engage with the vendors and the businesses and the customers that they have in front of them. And I think that this will give us the opportunity to sort of shine light on where some of those practices are abusive, and then business owners see themselves in the, oh, you're right, that's not fair. That's not a level playing field. That's not competitive. And there's something we can do about it. And so I'm excited for what is possible that we can uncover as this legislation moves forward and as folks get involved, make it happen.
Including us.
That's right.
Yeah. Thank you, Mark. Appreciate it. If you have any other words that you'd like to share, please feel free to do so right
No,
now,
just
and then
appreciate-
there'll be Q&A
Just,
afterwards.
okay, just appreciate y'all being here, and yeah, happy to chat afterwards.
Okay, thank you. Okay, now let me introduce Tom Papageorge. Tom, please take a few minutes to introduce
The
yourself.
hot seat.
Yeah.
A tough lead, but I'll do my best.
If you can just tell us a little bit about your work and what you do, just so that we all know.
Sure. I'm Tom Papageorge with the San Diego DA's office. But I'm here representing the California DA's Association, which, given all the alphabet soup of initials, you probably wouldn't recognize, CDAA. But it's all the DA's, city attorneys, and the AG's office who protect all of us from not only violent crime and street crime, which is what most DAs do, but also from white-collar crime and business fraud and practices of those kinds. I'm a longtime antitrust prosecutor. That is to say, I'm a longtime guy who does this stuff. And what I'm going to talk about very briefly, and then mostly answer questions, I hope, is what's this really about? I'm sure all the LAs in this room have a boss Angie, including even Tom, who's a friend of mine, who's supported antitrust reform. Gee, I keep hearing from a certain business organization, no names will be mentioned.
The chamber.
Protect the outrage. No names will be mentioned, but some organizations, I understand, they're representing their constituents, and that's what we do up here in Sacramento. And what I've done a great deal for the DA's Association. I've been the principal advocate for this stuff for the prosecutors of California for the past 25 years. I don't blame them for arguing for their clients, but I'm here to demythologize this bill. And when your boss says, oh, gee, monopolization, what's that? Are we going to have a flood of architectural barriers, lawsuits based upon this new law? We're going to have another ADA abuse it? No, folks, in about the next 4 minutes, I'm going to knock down those myths and tell you why the prosecutors of the state, who don't have a dog in this race, I don't get paid more if I have an antitrust law that's stronger. I don't get paid less. My interest, the interest of the AG, the DAs, the members of my association, are to protect consumers and honest businesses, and you've already heard from representatives of those, against a handful of folks who aren't playing by the rules. So what's the bill, and why is it that you should go back and say, hey, I heard from some people, and I actually think, boss, this does advance the interests of businesses, mostly smaller businesses, but also big businesses that play by the rules. The topic is monopolization. Don't let them tell you this is going to change all of regulation. No, it's not. We're adding to the California antitrust law a provision that's been a part of federal law for 136 years. Now, most of you will drift off to sleep if we start talking about the robber barons in the 1880s. But folks, from those high school history classes, you remember that we had monopolies of oil and gas and lead and sugar and cordage, and my pet peeve, a monopoly on whiskey. That's just wrong. Now, what does a monopolist do? Why the hell are we worrying about having AB 1776? A monopolist, as federal law has prohibited for 136 years, don't let that business organization tell you this is a radical, extreme new notion. The federal Sherman Act has had this exact monopolization provision for 5 generations. Well, those robber barons, what did they do? They raised prices, they excluded new and small competitors, set up barriers to entry. They, in the language of the economists, they abused their dominant position. Now, I'm not going to name specific big businesses, but if any of you follow the S&P 500 and FANG and other investment vehicles, you know that there are very large retailing, telecommunications, and other businesses that have now obtained 60, 70, 80% share of markets. And the reason we're here today is because when you have that much power in the hands of one business, consumers and honest businesses lose. Now, first myth, that this is a radical new expansion of California's regulations. It's going to drive business. Nonsense. The Sherman Act has prohibited this stuff for 136 years. Well, your boss will ask you, why do we need a California law then? The answer, and let's see if I can say this as diplomatic as possible. The answer is that policies change in the White House every 4 years. Have you noticed this? And sometimes the U.S. Department of Justice, I was a federal prosecutor for 4 years. I was a regional director of the Federal Trade Commission here in the Western United States. So I did this stuff for the feds too. And I'm telling you that sometimes the federal officials are active and aggressive in stopping monopolists like the robber barons, but sometimes they are not. California is the 4th largest economy in the world, and it should have a law that prohibits unlawful monopolization of an industry, driving out little competitors and raising prices for consumers. So all we're trying to do is give California enforcement officials, and by the way, DAs have been very active in antitrust. I brought the first ever felony antitrust prosecution and the first ever felony conspiracy antitrust prosecution way back in the 1980s. I was 7. Very precocious. No. But DAs have been very active. That's why I'm here representing the DAs Association. And we need a tool so that Californians can protect themselves against the robber barons of the 21st century. Now, once again, I'm not demonizing big businesses, but we have rules and laws that everybody has to play by. One of them is if you gain dominant market position, you can't exclude other little competitors and raise prices unreasonably. That's all this bill does. Don't let your boss or the person who's got your boss's ear say, oh, this is radical and extreme. We're just replicating what's been federal law for 136 years. Myth number 2. Why do we have to have this language about California antitrust law is somewhat different than federal law? Well, for 40 or 50 years, California Supreme Court has said the 2 bills, the Federal Sherman Act and the California Card Act, had different origins, and it turns out it's true. Now make no mistake when your boss asks, federal and state antitrust law are, and will continue to be, parallel. It's not like they're 2 different approaches, but there are some important differences. The Federal Supreme Court has said it's okay that there are differences as long as the laws are in parallel. California law wasn't based on the Sherman Act. It was based on other historical antecedents. And we need to tell the federal courts who haven't gotten this picture that California law has slightly different priorities and procedures. It's not radical. It's been the law in California at least since 1985. We're just codifying that. But the third and biggest myth I'm here to address is the floodgates of litigation. It's always one of my favorites. I've been author of the identity theft law and the price gouging and, not author, sponsor, and draftsperson, not author. Tell Tom I made that clear. Draftsperson for a whole bunch of these rules. And the concept behind all of them was the level playing field and to give us a tool to protect the public and honest businesses. And don't let the business folks say, this is anti-business. Hell no, it's pro-honest business. I have a lot of business colleagues that applaud what we prosecutors do. But here's the last of the great myths. The myth of the floodgate of litigation. Folks, we do have a problem in some issue areas. I don't want to get into it too much, but there are a handful of attorneys who bring serial architectural barriers cases without doing any real research and whether or not they're even valid as an issue. That's another problem we have to deal with. But don't let somebody tell you that monopolization laws are going to create a floodgate of litigation. Take it from any litigator you know, and please take it from this prosecutor. Antitrust cases are big, they're complex, you have to hire economic experts. Now they will provide a tool for small businesses in key circumstances, where a small bookstore is run out of business because the supplier no longer has a competitor and wants to triple the prices to that bookstore. That will give you, Christin, a solution. But friends, antitrust lawsuits are not architectural barriers cases that can be investigated in a day. They are big, complex, and not the kind of lawsuit that you're going to see filed. I'll buy everybody in this room lunch at the Sacramento restaurant of your choice. If after this passes, there's more than 5 or 10 of these lawsuits brought every year in the state of California. Don't let anybody lie to you. There's not going to be a flood of new litigation. There's going to be the DAs and AGs occasionally intervening to prevent that monopolist from driving a small business person out of business. There may be 2 or 3 private cases where a group of private small businesses get together to challenge the marketplace dominance of a big, well, fill in the blank, big company that used to be called something else and now calls itself Meta. No, I'm not going to say that. I'm not going to say it out loud, but you get the concept. The fact is, there will be a handful of targeted public enforcement and private actions to do what? To make a level playing field, to enforce the law that's been in place for 136 years in the federal law. So I'd like to answer questions. I'm going to wrap it up at that point, but let me summarize because it's terribly important. There has been lots of smoke generated, and I don't blame people for advocating for their clients. But don't let the smoke screen kid you. This isn't new and radical. It's something we've had in the federal books for 136 years. This isn't that the law of California is going to be radically different. No, it just is that there are small differences, and courts should respect them. And most importantly, there's going to be no flood of litigation that will hurt small businesses and big ones and drive businesses out of California. That is factually false. These are complex, rare but important cases. Let's give Californians, when DC doesn't care about us for a while, let's give Californians the ability to protect themselves from monopolists and robber barons. That's all this law will do. Now, I'll give you the ultimate sign of sincerity of a public official, my direct dial phone number. This may be a mistake, but I know how hard you folks work. I've got business cards here. Please come get one if you like. And call me if your boss says, but these people tell me there's going to be a wave of lawsuits and we're going to drive everyone out of California. When your boss says that, give me a call. I'll send you a couple, 3 paragraphs with case citations proving that this is mainstream antitrust law, just giving California an opportunity to protect itself when the feds won't. That's what this law is about. It's not about anything else. And I'm more than happy, on behalf of the DA's Association of California, to provide you that information and help. More importantly, I'd be happy, Yarissa, to answer questions. Are there some questions that your boss, don't be shy. My boss says, this organization says this is going to drive businesses out of California.
There's a question.
Yes, right here.
So, Rachel Buller with Senator
Hi,
Stone's
Rachel.
office, wondering, so it cuts both ways, right? I've had lots of conversations on this one.
Sure.
The necessity of the PRA, because that's mainly where, the frivolous litigation argument's coming
Right.
from. But then at the same time, we know how expensive these are. You need economists
Complex
and business
and-
analytics
yeah.
and all these things. So how is a small business like
That's
hers or
That's a
his
sophisticated
gonna be
question,
able to
and
do
I'm
that?
really glad that you asked it, because there is a potential internal inconsistency here. Let me explain it. The fundamental difference between an antitrust lawsuit and an architectural barriers lawsuit is enormous. You're not hearing that from the other folks who are talking about this issue. They're implying, well, there'll be dozens, if not, will not be the necessary litigation and investigation to put together a complex antitrust case. Take it from an antitrust litigator. It takes you 6 months to 18 months to put together an antitrust case and a lot of resources. However, when there's enough at stake, when a group of small businesses can demonstrate that a supplier has obtained dominant market position and is excluding new competitors by enforcing patents, by enforcing restrictive distribution agreements and the like, they will be able to band together and fund the difficult and expensive but necessary challenge to that monopolistic behavior. So I agree, there is some friction between the two, but I think they can be reconciled. No, there won't be a lot of these lawsuits. We probably don't want there to be a lot of these complex lawsuits, but there'll be a few when marketplace power is being abused to such an extent that, by the way, the PRA, of course, it stands for public right of action. It's the private lawsuits, the private right of action. The PRA is a significant issue, but look at American history. 90% of all the important monopolization cases that have ever been brought by the government. So frankly, with all due respect to my brothers and sisters in the private bar, my office will be bringing most of these cases. not the private ones. But a few can when they have the motivation to. Yes.
See, and that's exactly what I'm saying, is it totally solves the frivolous litigation issue if you narrow it to public attorneys doing
And that has
work.
been suggested. My friend Tom Umberg at one point raised that issue among others. Here's my 2 bits worth on that. My 2 bits worth on that is California has had the Cartwright Act in place since 1907, 119 years. The private right of action has been a part of the Cartwright Act since 1907. Have we seen a floodgate of bid rigging or price fixing or market division cases under the Cartwright Act? We haven't. If you could show me that private rights of action under the Cartwright Act have caused a problem of excessive litigation, then I would say perhaps you should consider having only public enforcement of the monopolization law. But I don't think you could prove that first part of our theorem. There has not been a wave of California private antitrust actions ever in 119 years. There's no reason to think there's going to be a wave of them now. Now, I'm not going to tell you, I'm a prosecutor, so I'm not going to tell you it would be bad to have prosecutors do this work, because we want to do this work. But I think I can honestly tell your boss, the way to check whether the private right of action is a problem is look back over the last 119 years. If you can show me a period when we had a flood of private antitrust lawsuits, then I'll stand corrected. But I teach this stuff and have for 35 years. I've been an active antitrust practitioner since the early 80s. We've never had a flood of private cases. So I believe the private action does not represent a threat such that it should be removed from this bill. That's my 2 bits worth. And once again, I don't have a dog in that race. It doesn't matter to me if there's private right action. But I see no pattern of harm over the last 120 years that would suggest there's going to be a problem in the future. Other questions? I don't want them monopolized. Oh, wait a minute. Did I just say that out loud? One more.
I know right now the Warner Brothers merger with, I don't even remember. There's like Paramount. Yeah, whoever was gonna buy them. So in the case that, let's just say this passes, would California be able to impact it on a national level? Because I know that it's not just here where that has to be stopped. So how would this interact with that?
Here's I'll keep it brief, because God knows you don't want an antitrust lawyer to go on and on like an antitrust professor would do, which I am also. The issue area you're describing is primarily addressed by another part of the antitrust laws, the anti-merger laws. In the federal law, it's called the Clayton Act. But through an interesting aspect of the Clayton Act, the state attorneys general can challenge mergers that threaten to form a monopoly. And right now, Mr. Bonta and a number of other attorneys general are challenging and have, by the way, gotten a stay order until the trial next spring in that very case. So we wouldn't use a monopolization theory to challenge a merger. We would use a merger theory. However, just to give you the other half of the equation, if that merger were to go through and that it would become a dominant motion picture producer who no longer wanted to distribute to theaters or tripled the price for streaming, that could be challenged by the AG or the DAs as monopolization. So the example you've given is one that's presently being litigated under merger law, but it would be a monopolization case if it went unchallenged and created a robber baron-like monopoly. Is that a fair answer?
Yeah, thank you.
Anything else, folks?
I do want to open it up. If you also have a question for Kristen or Mark, please feel free to ask them as well.
Let me, go ahead.
I have a question for Kristen. I live in San Francisco. You said that neighborhood commercial corridors had a hard time during the pandemic. Vacancies went up. My experience living in one of those kind of commercial corridors, not Haight-Ashbury, was that the commercial corridors also rebounded more quickly. That where downtown became a ghost town, the neighborhood commercial corridors became kind of vibrant centers of life. I think that has something to say about the mentality of small business owners, and we're wondering like how you kind of experienced that that period and how it speaks to the importance of small businesses.
Yeah, no, I think that small businesses want to be where the customers are. So we did see with downtown offices, having fewer occupancy, the landlords in the downtown area were still holding out for pre-pandemic rents, and it just wasn't a tenable business situation. So what you saw is that the neighborhood commercial corridors that had a lot of vacancies come about as a result of the pandemic filled in because maybe some of the landlords are a little more flexible. We had more mom and pop type landlords there as opposed to downtown having larger corporate landlords. But also we have in San Francisco the storefront vacancy tax. And the storefront vacancy tax applies to the neighborhood commercial corridors where it does not apply to downtown. So there was also the additional incentive created for the landlords in the neighborhood commercial corridors to get tenants. Otherwise, they'd be facing some potential fines for leaving their spaces vacant.
Other questions or thoughts? Yes, again.
Sorry.
Go ahead.
This is a question for the district attorney. One of the arguments that we've heard against AB 1776 is from the life sciences industry, saying that it will be impossible to conduct clinical trials in California, that it will be no longer possible to bring any kind of drugs on, into the market, et cetera, people will die. And just to get a little hysterical. Yeah. So I'm wondering if you could speak to that industry in particular and why there is a belief that's being argued that somehow in order to have a vibrant and innovative sort of drug manufacturing sector that you have to be able to engage in monopoly conduct.
That is an extraordinary argument.
Oh, it sure is.
And frankly, it makes almost no legal or practical sense. If I had to answer one word, if you're fans of the old movies, the one word would be plastics. Well, in this case, the answer is patents. Patents are enforceable for periods of multiple years, and there is absolutely no evidence that an anti-monopoly law will interfere with a patent law. Patent laws and the U.S. Sherman Act, passed in 1890, have coexisted for 130 years. Last time I checked, folks didn't say, we're no longer going to innovate in healthcare because if we do, we'll be sued for monopolization under the Sherman Act. Unless they can show me a single case. Now, by the way, important footnote, there are patent disputes and patent extension disputes. Some of them implicate monopolization issues. But I live in Orange County and work in San Diego, big healthcare industry. The colleagues I talk to, when they hear that argument, go, we don't understand. Yes, we're investing hundreds of millions of dollars developing this new product, but we will have a patent that will protect that enforceably for a period of time. Now, after the patent expires, if we try to expand our patent in illegal ways, perhaps we could be sued. But that scenario is a classic example of a smokescreen. Why has anyone innovated for the last 130 years if a monopolization law scares innovators out of innovating? That doesn't make historical or legal sense. Are there other questions?
There was one more question here, and then we'll take a couple of minutes. It's okay, Angie Chua, to give a couple of remarks about her business. She can tell you about that.
Sure.
So, we'll let you ask your
Yes,
question
another
first.
question.
Yeah.
This was to CAMEO, actually.
Good,
okay.
please.
Yeah,
To Mark.
you're off the hot
Give me a
seat.
break.
Yeah, you're off the hot seat. So how many lawsuits are you guys gonna bring after this comes? And on what grounds and for what, monopolies that are your small businesses are experiencing?
Yeah, I mean, we want to see what happens when this passes. I think we have no plans to actually file anything now. I think what we're really interested in is ensuring that there's transparency and a competitive playing field for both large and small businesses. If there are abusive practices that are happening that are monopolistic in nature, then they should be called out. because we believe that entrepreneurs should have the opportunity to compete with anyone, no matter the size. And just because you're big and just because you have a lot of power doesn't mean that you should be able to bend the market to your will at the expense of smaller businesses.
And let me just add to that, once again, all powerful businesses don't automatically violate the monopolization law. In order to monopolize and break the law, you have to prove that there is such market power in a defined marketplace. That is, what product are we selling and what geographic area are we talking about? There's so much market power that the monopolist has the ability to what the Europeans call abuse market dominance. And by that really is meant excluding competitors and raising prices far above the ordinary market level. That's a very difficult showing. I would guess that there not be a long list of lawsuits that either Christin or going to file, but if a particular supplier monopolizes the book sources that Christin relies upon, they'll have that capacity to do that. Once again, monopolization cases are not like architectural barrier cases. They are complex, and they only apply when all those criteria are met. And those criteria are tough. I would be surprised if there are more than a half a dozen of these cases filed each year in the state of California. But breaking up the oil, gas, lead, sugar, cordage monopolies in the 1890s, U.S. Steel, for example, brought in 1897, those are the kind of cases I anticipate will be brought either by the private, but more likely by the public sector.
And there is an example that actually Angie Chua, who is a small business owner as well, she can speak to that will give a lot more light into this. So please, Angie, feel free to take it away.
Stand here.
Come here,
If you want to
grab a
come over
mic.
here.
Come on up, this is the hot seat.
Okay.
So,
The hot seat is right, that's why I stood up.
you got it. Angie was featured this morning. By the way, I'm Robert Herrell, Executive Director, Consumer Federation, California. Medical appointments wait for no one, so that's why I'm late. I want to thank Yarissa and Jamie and the whole CFC team. I'd also like to thank all the co-sponsors. Raise your hand if you work for an organization that's a co-sponsor of this event. There are many of them, so I want to thank them all. You've had a great program, and Angie was at the unveiling of the Compete Act AB 1776. She also spoke this morning at the press conference with Assemblymember Majority Leader Aguiar Curry, Dolores Huerta, a number of other members of the legislature and business leaders, particularly small business leaders, about the bill. I want Angie to have a couple minutes to tell her story. I also want to embarrass her for a second. I'm a big traveler, and I like Lonely Planet books, and I like Moon, which is a company based in Oakland that does really interesting guidebooks. I forget where I was going, but I had a Moon guidebook, and I look at the back of it, and there's Angie with her. Not only is she, I assume, an avid traveler, but she's also moved her business into that space in a way that I find very interesting. So I think it's really important that you all hear Angie's story, because the word that, she may not say the word, but the word that I think of when I think about the story is stealing. And think about that in the context of what we're talking about for 1776. So with that, take it away, Angie.
Thank you. I would also use that word. So.
Okay. Oh, good. That's reassuring.
Hi, everyone. I'm Angie Chua. I own a stationery line called Bobo Designs Studio, where I design and create journals, tapes, stickers, etc. I also own a brick and mortar retail shop in Palm Springs, California, called Bobo Palm Springs. And as an artist and creator, I design a lot of the products that I sell. And in our store, we curate from other independent artists, primarily women of color and queer artists. So I go to great lengths to protect what it is that we create and the communities that we serve with the products that we carry. So selling on Amazon is not one of the things that we choose to do. So lo and behold, I was very surprised when I got a DM from a customer saying like, hey, I think your items are on Amazon. I was like, that's really interesting because we don't sell there. So I open up the app, put my name in, Bobo Design Studio, and my entire website, every product, all the product listings, the product photos, items that we had deleted from our site years ago, all were put on Amazon in a Bobo Design Studio storefront. So they had went and taken everything, our entire IP, our entire catalog, and created a storefront on their site. So I made a video about it, like, am I going crazy? Posted it, and the next morning I woke up and literally hundreds of other businesses had discovered that their entire websites were scraped and put on Amazon. And I think like the big the big red flag here is, how are they allowed to do this? How is Amazon allowed to take agency over where independent brands are able to put their products? The blood and sweat and tears that it takes for us to design these products, how we want them photographed, displayed, all of that was taken away from us so that Amazon could create a storefront to sell products that they don't carry. And so I've been in this, like, I color for a living. Like, doing this is not what I'm supposed to be doing, but here we are. And so I just hope that it's sort of like this big, like, canary in a coal mine of what these large corporations are capable of and how they plan to act with absolutely no guardrails in place and no accountability that they have to take at the expense of exploiting small businesses like myself. Because at the end of the day, like, my heart and soul is designing, drawing, creating, serving my local community of stationery lovers. It's not suing gigantic corporations like Amazon. I wouldn't even know where to start. I tried, and I found out that, like, I really don't have a place to start. So I think, you know, we should be thinking about, like, how can our legislative partners help us to protect small businesses like mine.
So I thank you, Angie, for telling your story. I find it ironic that someone who is as good at as advocacy as Angie is very humble about this is not what I do for a living. So when she's putting most of us who do advocacy for a living to shame. I want to thank everybody for coming. You can stick around. The panelists, most of them are sticking around for a while. If you have individual questions that you'd rather not ask in a group setting, there's more food and stuff like that. This is the last this year of the series of talks that we've been doing about, it started out with Are You One of the 19, which is this kind of groundbreaking story about the 19 households in America, globally, but particularly in America, that are controlling a kind of an eerie amount of the economy. It really harkens back to the old Gilded Age 1.0. The difference was that Carnegie and Mellon and some of the other folks, they at least some of them felt some sense of obligation and responsibility to society to build Carnegie Hall or giant libraries or parks or things like that. I don't know about you, I'm not getting that same warm, fuzzy-ish vibe, even if it's to stave off antitrust enforcement from the Elon Musks and the Jeff Bezoses and the Mark Zuckerbergs of the world. So this manifests itself in all kinds of ways. We thought, as we spent the year talking mostly, not exclusively, but mostly about antitrust, we started really high. And you can look and find all of these different seminars, some in person, some online. You can find them on our website or on our YouTube channel, if I'm not mistaken, and our socials. And we just thought, as session comes to a close now, with these last 3 weeks, it was time to really drill down. Because so many times, staffers like you have said, okay, so what do we do about this? What can we do? And this is something very, very specific that you and your bosses can do right now, between now and the end of August. And I cannot, and you know, I'm occasionally prone to hyperbole, but not too much. I cannot think of a more important public policy change that is pending in the legislature than this. So we appreciate your interest in coming, the questions, the engagement. I want to thank all the folks who appeared as panelists telling your story. Angie, Tom. Tom came up from SoCal. He's humble, but he's been doing this for a long, long time. And I've known Tom for quite a bit. And there is nobody sharper who is better connected in the DA's world. Whatever some of you and your bosses might think about other things that the DA's do, I want to be very clear, in the consumer space, there's about, on any given issue, between half a dozen and a dozen or a dozen and a half counties that are very active in these kinds of issues and trying to protect consumers, and we work with them all the time. So with that, if folks want to stick around and ask questions, feel free. There's more food. Thanks again to the CFC team and everybody, but thank you all so much for coming.